request for bill introductions. Representative Curtis, you can stay in your seat.
Thank you, Mr. Chairman. Yes, I'd like to ask that the committee allow for the introduction of RS 2766, which is the Clean Slate Automated Expungement Bill.
Any questions? Any objection? We will get that one introduced. Next to Willie.
On behalf of the Attorney General Derek Schmidt, we'd like to thank you for the opportunity to request this committee introduce the following bill at the request of the Crime Victims Compensation Board. It's 22 RS 2737. This bill would extend timelines for certain crime victims to file for compensation and increase the monetary limits on the compensation. Thank you for considering this bill, and we'd stand for questions at the appropriate time.
Any questions? Any objection? We will get that one introduced.
Thank you.
Anyone else with a request today? Okay, we'll move on to our hearings. I'll open the hearing on House Bill 2496 and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2496 would enact the Uniform Family Law Arbitration Act. Section 1 names the act, and Section 2 provides the definitions to be used throughout the act. Section 3 provides that the act governs arbitration of family law disputes. The act would not authorize the arbiter to make an award that grants a divorce, annulment, or separate maintenance, that terminates parental rights, or grants an adoption or guardianship, determines the status of a child in need of care, or determines the existence or non-existence of a parent and child relationship. Section 4 provides that, except as further provided, Article 4 of Chapter 5 would govern arbitration in other cases. In determining the merits of a family law dispute, the arbitrator shall apply the laws of this state. Section 5 provides that an arbitration agreement shall be signed, identify the arbitrator, and identify the family law dispute that is intended for arbitration. The agreement to arbitrate a child-related dispute that arises after the agreement is made unenforceable unless the parties affirm the agreement in record after that dispute arises, or the agreement was entered during a family law proceeding and the court approved or incorporated the agreement in an order issued by the court. If a party objects to arbitration on the ground that the arbitration agreement is unenforceable or does not include a family law dispute, then the court would decide whether that agreement is enforceable or includes that family law dispute or not. Section 6 provides that a party can initiate arbitration by giving notice to arbitrate. Section 7 provides that a motion for judicial relief has to be made in the court in which the proceeding is pending. If there is no pending proceeding, then a court with competent jurisdiction over the party is in the subject matter. The court can compel arbitration if there's an agreement in compliance with Section 5, unless the court determines the arbitration is not in the best interest of the parties and should not proceed under Section 12. That section also provides the reasons a court is required to terminate arbitration. Section 8 requires the arbitration to be, the arbitrator, to be an attorney or a retired judge. If an arbitrator is unable or unwilling to act, the court shall select a new arbitrator to oversee the case. Section 9 requires individuals to disclose any fact likely to affect the impartiality of the arbitrator. Section 10 provides that a party may be represented by an attorney or accompanied by someone who is not called as a witness. A party or representative shall not have ex parte communications with the judge who would otherwise be assigned to that case. Section 11 provides that before an arbitrator is selected, the court can enter temporary orders, and those temporary orders would remain in those circumstances until the dispute is resolved. Section 12 defines protection orders. If a party is subject to a protection order, then the arbitrator shall stay the arbitration and refer the parties to court unless certain determinations are made. Section 13 requires an arbitrator to conduct an arbitration appropriately, and each party has the right to be heard. The section also lists the arbitrator's powers. Section 14 provides that arbitration hearings do not need to be recorded, but a verbatim recording must be made part of an arbitration hearing if it concerns child-related disputes. Section 15 requires an arbitrator to make an award in a signed record. That award has to state the reasons on which it's based. An award that deals with a child-related dispute has to state the reasons on which that order is based as required by law. And an award is not enforceable as a judgment until it is confirmed. Section 16 allows a party to move the court for an order confirming an award from arbitration. The court has to confirm the award if the parties agree in a record to the confirmation, or the time has elapsed if no motion is made. If an award determines child-related disputes, the court has to confirm if the award on its face complies with Section 15. Section 17 allows an arbitrator to correct an award on a motion of a party within 30 days of giving notice of the award if that award has evidence of a mathematical miscalculation or a mistake. Section 18 provides a method for the court to correct that award. Section 19 establishes reasons the court would have to vacate an unconfirmed award. Section 20 provides that if the meaning of a confirmed award is in dispute, the parties can agree to arbitrate or proceed to court if they so choose. Section 21 requires the court to enter judgment in conformity with the order. Section 22 provides that if a party requests modification of an award, the parties can proceed under the dispute resolution method specified in that award, or they can agree to arbitrate. Section 23 requires the court to enforce a confirmed award. Section 25 provides the actions that are eligible for appeal. An arbitrator would not be competent to testify and shall not be required to produce records unless it's necessary to determine a claim by the arbitrator against a party or a motion to vacate an award. And if a person commences a civil action against an arbitrator and the court determines the arbitrator is immune from liability, then the court would award the arbitrator reasonable attorney fees. Section 26 requires consideration be given to uniformity of law. Section 27 talks about modification of federal acts. Section 28 applies that act prospectively. Those three portions are very common in uniform acts like this. And I can take any questions.
Any questions? Representative Carmichael.
Thank you, Mr. Chairman. The committee will be glad to know that I had 4 questions in mind, but I've already forgotten one of them. First, can someone here refresh my recollection? Was this offered on behalf of the Kansas Bar Association? I think that's who it is.
It was.
Okay, that helps me with my bill brief. Secondly, Ms. Scott, I was engaged in plagiarism this afternoon, preparing my bill brief by cutting and pasting your work. And at the bottom of page 2 in section 17, the brief as well as your oral brief today says giving notice of the award if the award has an evidence mathematical miscalculation. I just wonder, is the word has an evident or is it something different? Because I didn't have time to get back to the bill.
Yes, Mr. Chairman, and Representative Heiberger is normally the one who corrects these clerical errors in my bill briefs, but I'm happy to answer that for you too. If you turn to page 7 of the bill, that's where that's taken from, line 19. It should be evident mathematical miscalculation.
Well, I was busy preparing an amendment to try to show how smart I was. If I could direct your attention to page 3 at the very top, this is the next sentence. If the award, if imperfect, in a matter of form, what is the language? If the award is imperfect?
Yes. Should
I've
be.
run out of amendments to make, Mr. Chairman. Thank you.
Any other questions or corrections for Natalie? Representative Humphreys.
I would never correct Natalie. Thank you, Mr. Chairman. So do we have a Family Arbitration Law Act now, and this is just replacing it? Or what do we have in our statutes now about arbitration?
So, Madam Chair, I don't believe, or Mr. Chair, Representative Humphreys, I don't believe that we do currently have a specific Uniform Family Law Arbitration Act. We do have other arbitration statutes on the books, obviously, that could apply in some of these cases, but this would be enacting a new uniform act just as it relates to family law disputes.
Okay, thank you. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chair. Bad news for the committee. I remember the fourth one. Haven't we seen this before somewhere, sometime?
Now that's the question I was expecting from Representative Carmichael. Yes, you have. In 2019, you guys heard this bill. It was House Bill 2533.
Thank you, Mr. Chair. Oh, by the way, what fate did it meet, if you recall, since you'd already looked it up?
Oh, and you guys, it was also in it was introduced in 2019 then, right? And heard in 2020 then, I believe. Is that here? Well, we'll just let Bob.
I thought we kicked it out of this committee favorably, but I may be wrong. I haven't had time to look it up.
You did.
Yes, Bob.
Thank you, Mr. Chairman. So the last time it was heard and worked was 2020. It was introduced as 2533, and it was reported out favorably, but it was stricken by Rule 1507 from the House calendar.
And, Mr. Chair, your answer causes me to suspect that perhaps we've heard this more than once, Mr. Gallimore, or was that our only sojourn?
My notes reflect that was the only time. I said the latest out of an abundance of caution.
Consistent with my recollection as well. Thank you, and thank you, Mr. Chair.
Anything else for Natalie? Representative Keither's hand was waving in the air, but I think she was just losing her balance. So. Okay, let's move on to proponents, and Larry Root is here today to tell us what this is all about, in addition to Natalie.
Thank you, Mr. Chairman. Off. Oh, here we go. All right. My name is Larry Root. Mr. Chairman, members of the committee, I appreciate the opportunity to speak with you today. All the previous information is correct. I like the amendments, by the way. Yes, it was taken up in 2020, and then COVID hit, and things fell off the rails. And so we just decided to wait a year or two and bring it back. And my background, I'm with the Kansas Bar Associations. I serve as legislative liaison for the dispute resolution section of the KBA. I'm a reformed family law practitioner, former trial attorney. In the last 25 years, I've been pretty well doing mediations and arbitrations throughout the state through my office here in Topeka and our office in Lawrence and Kansas City. This act, the reason the Uniform Law Commission became interested, I think, is that Colorado, New Jersey, North Carolina started developing their own family law arbitration systems, and the Uniform Law Commission thought, maybe we ought to get our arms around this and make sure that each state has a similar system so we don't bump into one another, have a different system in Missouri than we do in Vermont than we do in Arizona. I was asked to serve as the ABA's representative on the committee. I served with, we have a speaker coming up, Professor Linda Elrod, who was our recorder, who was extremely knowledgeable in this area, and with Barbara Atwood out of Arizona. A very good committee made up of arbitrators, family law practitioners, folks that were interested in this particular area of the law. So how this works, I'm just going to summarize a lot of my testimony. I'm sure you don't want me to read every word, so I won't. But once the parties put together in writing that they want to have an arbitration of their dispute, their family law dispute, they have to pick an arbitrator organization. They must identify that dispute. What is it the arbitrator is going to be working on? And then having done that, then once the arbitrator is notified, there's a preliminary hearing conference to work on how long the hearing is going to be, when it's going to be, the timing, what sort of discovery, what sort of motion practice. It runs very much like an abbreviated court proceeding, although it's hopefully faster and We can do it at a time that meets the needs of the parties. We could do it on a Saturday. We could do it at night. We could meet with work schedules of people. So what's happening in Kansas is, the previous question was about whether there is a Family Law Arbitration Act in place currently. No, but we've passed the Uniform Arbitration Act in 1955, and again, the revised Uniform Arbitration Act in 2018, which provided additional due process protections for parties. And we waited till we could get that act passed until we attempted to present this one, because the Family Law Arbitration Act builds on the Uniform Arbitration Act and the Uniform Arbitration Act. So it all kind of fits as a hopefully a seamless idea. What's different about family law, and those of us who have served on the committee, we had a couple of concerns in particular, that of what happens if there's domestic violence. Another concern is, well, shouldn't the court be looking at the best interest of the child and the proceeding if it's a child-related matter? And so the arbitrations are different in the family law arena than in the commercial arena. I'm a commercial arbitrator. I handle arbitrations for a number of different national and regional groups. But what's different here is if there's domestic violence, we're going to stop the process and send it back to the court for determination whether the process should continue. That includes protection orders. Another issue is that if we're working on a child-related matter, whether it's custody, residency, parenting plan, visitation, child support, we want to have a record of that the court can see and approve to make sure that we're following the statute and that we're following the best interest of the child doctrine. So that's the difference with family law arbitration than a regular old commercial arbitration that you might have been involved with at some point. So the other some advantages, I think, are that you can pick the arbitrator based on their experience and reputation. We can pick someone who's a retired family court judge. We can pick someone, the parties could pick a child psychologist. There are all kinds of, if you have a pure division of assets case, you may want somebody that really understands what a subchapter S corporation really means and how you're gonna deal with that. And so there's a lot of opportunities to pick the right arbitrator for the right case. It's the parties that choose the issues the arbitrators are going to take on. The parties and the arbitrator will determine on the time and location of the hearing, determine evidentiary and discovery questions. Confidentiality is a major issue that many of us on the committee were very interested in. There are cases where parties would prefer not to share their financial structure or perhaps their business structure with the Western world, and would like to keep that information private. And we think that's an important issue that, or important benefit of family court arbitration. As pointed out, there's some things the arbitrator cannot do. We can't grant a divorce, annulment, separate maintenance. We can't terminate parental rights. We cannot grant an adoption or guardianship. We can't determine the existence or non-existence of a parent-child relationship or the status of a child in need of care. Those are all matters for the court. But when it comes down to child-related disputes, the court continues to be involved, as they've always been involved. They have to approve these awards when they come down, and there has to be a record maintained. The U.S. Supreme Court, federal statutes, the Kansas Supreme Court, Kansas Court of Appeals have all supported arbitration in various instances, and this is an area that I think just adds to a tool that a dispute resolution attorney or a court can utilize. We already have a lot of tools out there. We have mediation, we have case management, we have conciliation, we have parent coordination. This is yet another tool. And it just adds to the armory of things we can do that parties can select to rapidly and hopefully efficiently resolve their matter. I stand for any questions.
Questions, Representative Carmichael?
Mr. Chairman, I see that you have eyes in the back of your head. I'll have to be careful in the hearing room from now on. Mr. Root, I appreciate you being here. I appreciate the Bar Association bringing this to us. I support this legislation. There are a couple of areas, though, that you touched on in your testimony that I want to make sure I clearly understand. In the context of commercial arbitration, labor arbitrations, we oftentimes hear the phrase, the parties contract for the opinion of the arbitrator, be it right, wrong, or otherwise, in essence, meaning the court typically rubber stamps and doesn't dig back in to see whether the arbitrator made an error. That may be a gross overstatement, but are you following where I'm at?
What the court can do in a normal commercial arbitration is the only thing the court can do to overturn that arbitration award is if there's been fraud or malpractice,
Jurisdiction.
bias, that sort of thing.
Right.
Here, there are those same rules, but also we don't want a rubber stamp. We want the court in child-related matters to take a close look at it and make sure the statutes are being followed and that the best interest of the child is being followed as well.
By way of example, if the arbitrator is called upon to determine the relative assets of the parties, and the arbitrator errs, says there's $10,000 instead of $100,000, does the court or do the parties have the opportunity to go to the court and say, the arbitrator blew this one, it just misinterpreted the evidence? Is that possible, or is it more like a commercial arbitration where you get what you got?
No, for clerical errors, that sort of thing, you're given 30 days.
I didn't mean clerical. I meant substantive error in determining the facts. The arbitrator just blew it. No reasonable person could have reached such a conclusion.
Well, then your argument is that no, as you say, that the arbitrator was so far afield on state law and on how normal division of assets matters are handled. Maybe that should be vacated. Those are hard to vacate. You know, I'm going to be straight with you. If the arbitrator is not has not created some sort of a fraud or some sort of a bias by not reporting who they've worked with and so forth. We have stringent requirements as arbitrators, both in the commercial and this, to tell everyone exactly what our background has been with those parties. And if we have some background with them, we have to leave. We cannot.
Right. But, Mr. Chairman, with your permission, I'm not really following Mr. Root. I'm sorry. I'm talking about the situation, really perhaps two different situations.
Right.
One where the facts are completely in opposite of what the conclusion the arbitrator reached. But the other one is, of course, where the arbitrator chooses to believe one witness over another, makes a determination. I think she's telling the truth. I think he's lying. Hence, I'm going to incorporate her version of these facts into my award. Can the party who is aggrieved by such a decision then go to the district court and say, but Judge, the evidence could have reached a different conclusion, and we think you should substitute your determination of credibility for that of the arbitrator? Do you get a second bite at the apple through the district court under this statute?
With this statute, you do not get a second bite of the apple. If there's been a credibility determination made, that determination has been made and it cannot be vacated.
And I don't disagree with that, because we all know matters of timeliness, finality, and expense come into play. The second example, though, with the chair's permission, would be erroneous application of the law. The arbitrator misinterprets the law or misses that leading decision of Frick versus Frack, which would have led to a different conclusion. Can the parties go to either the district court or presumably the Court of Appeals and say there was a misapplication of the law by the arbitrator and that decision should therefore be set aside?
Very frankly, and again, I'll be honest, if there's been a misapplication of the law, unless there's just something I can't even think of, that case will also not be vacated. The court must approve the award of the arbitrator.
And once again, the concept there is that we want to resolve these matters promptly, expeditiously, and inexpensively. And if all this is an advisory opinion from an arbitrator, then perhaps all we've done is multiplied the expenses. Would that be a generally fair interpretation?
You know, when you were mentioning this, I used to handle case management cases in family law. And those are advisory suggestions to the court. The court could go ahead and rubber stamp it, which they didn't often do, but they might take it to a further hearing. There is a second bite of the apple. With arbitration, there is no second bite of the apple unless there's been something egregious that's happened.
But that is for good reasons that we have discussed. Thank you, Mr. Chair.
Any other questions? Oh, yes, Representative Schreiber.
Thank you, Mr. Chairman. Thank you, Mr. Rood. Just out of curiosity, I'm a little familiar with court-appointed special advocates for a child. Would that person be allowed in a mediation, or is that something separate?
Yes, if one of the parties wants just an advocate, they can have their attorney, obviously, but if they want an advocate to be with them, as long as that advocate's not going to be testifying, that's perfectly permissible.
Okay, thank you. Thank you, Mr. Chairman.
Not seeing any other questions, we will move on to Professor Elrod, who is online. Good to see you, not at the zoo.
Yes. Can you hear me?
We can, yes.
Okay, thank you. It's a little strange format, so I can only see a couple of you. But thank you for the opportunity to be here. I have submitted written testimony. I think that the other two have covered the main parts of it. I want to mention a couple of things. You're talking about second bites of the apple, and no, you can't do it, especially on property matters. The parties could, however, when the arbitrator came down with that award, they could ask the arbitrator to correct it. And that might have happened at an earlier stage at that point. So you might not have gotten to the point where it is a final award because they screwed up totally. Secondly, if it's a child-related issue, and this is the main reason why we're proposing this, is we don't think you ought to be arbitrating family law matters under the general arbitration statutes, even the revised one, because they do not have any safeguards for children and child-related matters or for domestic violence victims. And those are two things that make family law different. And some states don't even allow any arbitration. There are only two of them, but there are two states that don't allow arbitration of child custody because they think it takes away power from the judge. We don't think it does if we put in the safeguards that we have in this act. And the safeguards are that we don't hold you to arbitration of a custody dispute unless you agree at the time the issue arises. You know, in usual arbitration, the parties sign an arbitration agreement and it may be years before the issue comes up. They may, and it's okay. The Arbitration Act allows that. The Supreme Court's affirmed it over and over again, that if you make an agreement to arbitrate, then you're stuck with it, and you have to arbitrate. Well, that's fine for money matters. And we think if people in a prenup want to go ahead and say, we're going to arbitrate our money matters if we decide to get divorced at some point, that's fine. But we think that custody issues should not be coerced, and that parents should make the decision if they want the custody issue to be arbitrated at the time the issue arises. And so that's one protection that's in there, is we don't allow pre-dispute, 5 years before agreements to arbitrate custody issues. Secondly, we require the arbitrator to make findings of fact, conclusions of law, and to record, and not a court report or not anything that's going to cost a lot of money, but to have some type of a record so that we can see, a judge in affirming the award can see that the arbitrator did look at our factors in 23-3203 for custody, because those factors are in there for a reason. You guys spent a lot of time putting those factors in there. And they are factors that bear on the best interest of the child. And so that is another protection for children. So I think those are the main things. I've had a couple of questions, and I think there is a confusion. Some people think that only lawyers or judges can arbitrate, and that's not true. You have to read this section carefully, but let's say that your issue, and I think I put it in my testimony, one of the persons who came and talked at our meeting when we were drafting said that their only issue in a case involved a toy train part. And I have no idea because I'm not quite that into toy trains. I do ride the one at the zoo, but that's about as far as I'll get with trains. But that issue involved something that could have been anywhere from like $1,000 to like $22,000. I don't know how a train part, like a little one, could be worth that, and the parties wanted that one piece of the case arbitrated. Well, I don't know about you, but I, as an attorney, and I'm not sure many of our judges are going to be any better at figuring that out. The person you want to arbitrate that is somebody that's dealing with them on eBay or Etsy, or somebody who's dealing with that particular issue. So the parties can choose their arbitrator, and that person doesn't have to be a lawyer, a judge, or trained in domestic violence, because all you're doing is a train part. And so if the parties choose, they can have anybody arbitrate their case. What's going on now is mainly, and people are using the RUAA in family law cases, but they're mainly just doing money. And they're using people, I don't know if you know Steve Blaylock in Wichita, but they're using people like him who have been practicing family law for 40 years now. And they use them to make those determinations as to values and property types of issues. You're probably going to want that. You may want a retired judge. I can tell you, Judge Beasley, I thought, was a very good family court judge down in Wichita for years. If he decided to be an arbitrator, he would be excellent at child custody arbitration because he has that. But you know what? A clinical psychologist might be the person you want to determine if you have a special needs kid who needs certain types of stability, certain types of parenting plan. You may want somebody who is an expert in that area to help the parties do that parenting plan. And so what I see this as is a great boon for parents who want to use it because it gives them self-determination. They get to choose the decision maker. They can choose someone who's an expert in whatever issues they have. They don't have to arbitrate the whole thing, but sometimes there's just one piece that stalls everything. And sometimes if you can just get beyond that one piece, then things will settle and the parties can come up with their own agreement. So I see it as part of a parental rights. New Jersey's case that preceded their court rule basically said parents have a constitutional right to the care, custody, control of their children, and that includes the right to determine the forum in which their custody dispute is arbitrated or determined. And I thought, if you believe in parents' rights, that's true. The parents should have the right to determine whether it's done through an arbitration, whether they go to court, whether they go to mediation. I do not think arbitration should ever be mandatory or forced on people. It should be voluntary. So I would be happy to stand for questions.
Any questions? Looks like you're getting off easy today. Thank you.
Thank you. Do you
Committee,
need me to stick around or?
You're good. We're
away?
about to close this one up. Yep,
Okay.
You can go away.
Thank you very much. I can go away. Okay. Bye, guys.
She asked, can I go away? Okay, we have written proponent testimony from the Uniform Law Commission and from Ronald Nelson. Anyone else as a proponent? Do we have any neutral or opponent conferees? Okay, we'll close the hearing on 2496, open the hearing on House Bill 2447, and again, ask Natalie to come up.
Thank you, Mr. Chairman. House Bill 2447 terminates the transfer of the remaining unencumbered amount in the Securities Act fee fund over $50,000 to the state general fund. Current law in KSA 1712A601 provides that on the last day of every fiscal year, the Director of Accounts and Reports shall transfer any unencumbered amount in the Securities Act fee fund that is over $50,000 to the state general fund, so that at the beginning of the next fiscal year, the unencumbered balance in that Securities Act fee fund would be $50,000. The amounts transferred are to reimburse the state general fund for accounting, auditing, budgeting, legal, payroll, personnel, and purchasing services, and any other governmental services which are performed on behalf of the agency by other agencies that receive appropriations from the state general fund to provide those services. This bill would terminate that transfer. And so that transfer from the Securities Act fee fund to the state general fund would no longer take place. And I can take any questions.
Any questions? Thank you, Natalie. Committee, just a little background in case you pull this up, you'll see that we had a hearing on this last year, March 24th. It was a bill that we quickly introduced because of the litigation, and then determined to wait until that litigation was resolved. And so we addressed this issue with the budget proviso last year. It's now time to hear this again. We had the hearing last year because I wanted a blessed shell to deal with in case we needed it. So now we're having a true hearing on this. The budget director reached out last week and a half ago, asking if we'd take this back up again. And we are, and the Attorney General's office is here to speak as a proponent and explain it. So Jeff, come on up.
Good afternoon, Chairman Patton, members of the committee. My name is Jeff Cheney. I'm appearing on behalf of the Office of Attorney General in support of House Bill 2447. This bill is the final piece in concluding the litigation that was captioned Thomas Bloomer versus State of Kansas. It was filed in the district court back in 2019, and it was a challenge to the fee fund sweeps from the Security Act fee fund that were pursuant to KSA 1712A601 subpart A and also KSA 753170A. By operation, the sweeps from the Securities Act fee fund grossly exceeded the amount that was necessary to reimburse the state general fund for its legitimate expenses that are all set out in the law. Due to prior case law, after we got into discovery and working on the case, it was determined that this was a matter that really needed to be settled, resolved, short of going to trial. Last year, when it was brought before you, we were working towards a settlement. We did not conclude it back in March and April like we thought we might be able to, but we did wrap it up with a settlement agreement at the very beginning of June. This went to Judge Teresa Watson for approval of the settlement agreement, which she did approve back in September of last fall. And ultimately, the case was dismissed in October of last year. There was only one part of the settlement agreement that was left to be done, and that was the passage of the provisions of this House bill. So what the agreement called for is, because we cannot obviously dictate to the legislature what you do, is that we would agree to recommend that you strike the language that you see in the bill, which would effectuate, basically end the fee fund sweep in this case. So that'll put an end to it. All the financial terms have already been accomplished. The fee funds, for all practical purposes, have been stopped by virtue of a moratorium that has been put into place. So there's nothing currently being taken out. Anyone that had been subject to it right now under the moratorium, they're not paying into the fee fund until basically it can get brought down to a point where it's back down to a reasonable amount again before they're assessed a fund or assessed a fee for the services that are appropriate for their profession. And so this is the final piece, and we would just simply ask that the committee pass favorably these amendments.
Any questions, committee? Look online. We don't have any. Thank you.
Yeah.
Anyone else here as a proponent? Anyone as a neutral? Any opponents? Seeing none of those, we will close the hearing on House Bill 2447. Okay, committee, let's look at House Bill 2299. I'm just going to go in order, Natalie. That works. And we'll have Natalie remind us what this bill is about.
Thank you, Mr. Chairman. House Bill 2299 would increase the amount of time law enforcement has to serve, to execute a search warrant. Right now, it's 96 hours from the time of issuance. This bill would change it to 10 days.
Any questions for Natalie? Are there any amendments? Representative Owens?
Thank you. Kind of late getting this together, so my apologies for that. But if Natalie would send that out, or we could get that emailed out. Quite simply, the amendment that I propose after having at length conversations with law enforcement last night would extend it from 10 days. So currently we're at 96 hours. Instead of 10 days, it would be 14. Currently, Colorado is at 14. All of our neighboring states are at 10. And it's my belief that the more time that we give law enforcement to execute these warrants, then the less likely we run into problems or they're put in a situation to put their lives at risk or the lives of others. So I would just offer that amendment for consideration.
So process-wise, everyone, this year, we're going to do the same as we did last year. So as soon as someone says they have an amendment, assuming Natalie knows about it, Natalie will email that amendment to Kathy. Kathy will then distribute it, and then Natalie's going to take control and stick it on the screen. So you should have it in your email, which I do. You'll have it there, and then if for some reason you don't have your computer and you have really, really good eyesight, you'll be able to see it on the screen. Okay, so... you've made a motion to amend. Do we have a second? Representative Neely, discussion on the amendment. Representative Carmichael.
Thank you, Mr. Chairman. When we have heard or considered this type of legislation before, I had reluctance to extend the 3-day period that's presently provided for in Kansas law. After I listened more carefully to the testimony of Mr. Klump concerning no-knock search warrants, the extension of time as it related to no-knock search warrants and the very helpful testimony we had in that regard in corrections, I became persuaded that 10 days is a good idea, if for no other reason, because it gives law enforcement an opportunity to enter the premises under circumstances that might be more safe if they're given additional time to surveil and find an opportunity to go in and serve the search warrant when bad guys are not sitting there cleaning weapons with their children in the front room. However, there is a countervailing factor, and that is that we don't issue general warrants in the United States that says the police can go search anytime, anywhere. This is Representative Wheeler's a bad man. You can go search his house anytime you want. Rather, it's limited in time because oftentimes the existence of probable cause for a search is likewise limited in time. And frankly, we don't want law enforcement officers driving around for days, weeks, or months and saying, you know, I'm going to bust down John's door, but I think I'm going to wait till he really has something good over there. And so there's a balancing factor between 72 hours, 10 days, and 14 days. And for me at least, while there's no correct and right answer, for me at least, I like what Kansas law enforcement asked for in the first place, and that was 10 days. I appreciate the reason for the amendment. I participated in some discussions last night. I stayed away from the scotch. I listened carefully. But in this instance, Representative, I'm not sure that I'm ready to go quite this far. Thank you.
Further discussion? Not seeing any online or in person. Representative Ralph?
Thank you, Mr. Chair. And I apologize because I think I missed out on the hearing portion of this. But in terms of conversations with law enforcement, what were they saying to you about that?
Great question. So, as we were visiting about this, talking with a number of them yesterday evening at the event, the thought was, while 10 days is great, it was certainly much better than 96. Their thought was with 14, they would be able to have 2 weekends and guaranteed to have 2 weekends to work through the process to find the best time to enter that residence based on work schedules and people coming and going and things like that. So it was more of finding the most convenient time and having 2 weekends.
So just for clarity for anybody who's watching on the proceedings, and when you say that this isn't then coming necessarily from association positions, but generally conversations with individuals within the law enforcement community.
Yeah, that is correct. This is not an official position. This is something, after hearing the conversations and talking with various stakeholders, I thought, you know what, let's bring this up for a conversation amongst the body by bringing forward this amendment.
Yeah, I appreciate that. And I think probably anything we can do that would make things safer, I would normally be in favor of. I'm hesitant to go past what they've actually asked. We keep saying they, I apologize, from what the official, if you will, position is. If going out farther is something that the associations or the groups say they would like to have, I'd be more than willing to be open to that. Thank you, Mr. Chair.
Any further discussion? Representative Schreiber.
Thank you, Mr. Chairman. This might be for Natalie, but so the original bill had 96 hours. Now we're talking days.
The law is currently 96
Currently,
hours.
I'm sorry. So why is, and I don't want to have a large number in there for number of hours, but is there a reason why one's in hours and one's in days? Do they start, if he signs it, if the judge signs it at 8 p.m., does it go clear to 8 p.m. for 10 days, whatever later?
You want this one, or Representative Wheeler? He's got an answer. No. Natalie. Well, yeah, Representative Wheeler, go for it.
I think Representative Schreiber has a very valid point in that what is defined as a day and when does the day begin? It's an 8-hour day, it's a 12-hour day, it's a 24-hour day. We consider it 24, but I think his point's well taken. Beginning from here to here, even though that is a large number, but it's clear.
Natalie, do you want to explain why just explain what you're thinking. Can't quite read her mind.
Thank you, Mr. Chairman. So I would note that you'll see in the bill there that we are striking 96 hours. It was 96 hours from the time of issuance. When you're talking about just that kind of short amount of time, now that we've gone to 10 days, we struck time and we put date. So it would now read, shall be executed within 10 days from the date of issuance. So it has to be less than, the end of those 10 days.
So it could almost be 11, right? If it's issued really late or really early on a day, you'd count 10 days after that.
Okay, so if it was issued at 8 a.m. on the 1st, then on the 15th, it could go till midnight on the 1st or the 15th?
Yes.
The time that it was issued will no longer be a factor. It will just be the date that it was issued.
Okay, thank you. Thank you.
Representative Carmichael. Oh, Representative Samsel.
Thank you, Mr. Chairman. I'm going to show how little I know in this area, but when you have a search warrant, is there a certain address, or do they already kind of have a plan of when they're going to go do the search? I'm just trying to understand between 3 days, 14 days, 10 days, what's reasonable for them. Otherwise, I tend to think maybe we bite off a little bit, and if 10's not good enough, maybe we extend and go 14 from there. But if when the thing's issued, they kind of already have a general idea of when they might be able to inspect, I guess I don't know if anybody has any insight on that, but as a civil litigator, I certainly don't. And the only part that now that we started talking about time and days, if we want calendar days versus business days, I know plenty of lawyers who've argued about that. And I wouldn't want something being invalidated on the ground that we meant one and not the other. So those were my thoughts as I looked at it.
Representative Neely.
I think I can understand a little bit where the law enforcement community is coming from when they're looking at the potential of going in safely or finding a potential time to go in and conduct that search warrant. For example, there might be certain things that are happening on that day. An example that the children are out of the house at that particular time. And if we give the 14 days instead of 10, let's say it falls on the third day that they decide that's the best time to go into that residence or something along those lines, then they can't go to the following week on that day to safely do that. And by giving those extra 3 days or 4 days, we've given them that entire time period to say, this is the best time that we can go in there and do it safely and, you know, accomplish what it is that we want to try and accomplish.
Representative Carmichael.
Thank you, Mr. Chairman. I appreciate this good discussion. First, the representative from, what's that town over there, Mark? Wellsville. Yeah, my friend from Wellsville, I think, raises a good point about counting rules. Intervening days, intervening weekends, holidays. There's a case called McIntosh versus I can't remember, which strangely applied the counting rules from the Code of Civil Procedure to a whole gamut of other types of cases, and it's 6208. I can't remember the citation number. I remember the case because I won it and saved somebody's bacon. But at any rate, they then, and I charged them, but they then, the federal system made changes in counting rules, and I see my friend Representative Ralph may be more up to date on this. We don't want to inadvertently mess this up. The other thing, thinking about Representative Neely's point, that, you know, you may get to the end of the 10 days and we just haven't had that golden moment to go in. We had some testimony, I think it was in corrections, if I recall correctly, that these types of warrants can be renewed and or reissued. In other words, you could get a 10 days, right now you can get 96 hours, and if you don't get it done in that time, then you go back to the judge and you show the judge the probable cause for the issuance of the warrant still exists. And by the way, if it doesn't exist, you shouldn't be going into search. And you, in essence, renew or reissue the warrant in those rare instances where you couldn't get it done within 10 days. And I think perhaps an appropriate balancing is that if you go 10 days and you haven't executed the warrant, maybe it would be a good idea to go back and touch base with the judge and see if there still is probable cause for the issuance, but also the execution, if you will, of that warrant. I think that's a right all of us as Americans would kind of like to have, a little bit of security in our own home if the probable cause is dissipated. So that's my thoughts.
Representative Owens.
Let's say I've got Kathy right in your head, so
I know, I appreciate it. Yeah, do that. I'll catch one of your hands if you do that.
You know, first of all, I'm going to say that I'm really glad that Representative Carmichael didn't have a scotch last night, because today he's making some very valid points, and that does that plays into things, right? I mean, so anyway, I actually very much like what he said. Now we can have a different conversation about the calendar days or the hours, but I like that idea of 10 days and then renewing it after 10 days. I think that's a very, very valid point. And with that, I'll go ahead and withdraw my amendment.
Good with that, Representative Neely? Okay. The amendment's off the table. Natalie, do you have any concerns at this point in time with the days? The way, I mean, do we need to do anything, or do we want to tell me your thoughts?
Mr. Chairman, I think that would be for you guys to decide whether you.
No, not the number of days. Do we need to clarify the 10-day piece, how it's being counted?
I would leave that to you to determine whether you think that needs to be clarified.
My thinking is we don't deal with it today. And if we're comfortable moving the bill forward, we can visit with people before it becomes up for debate. And if so, we can tweak it at that point in time. This is not something I'm confident we can fix right now. Representative Samsel.
My only thought, Mr. Chairman, is if we just inserted the word calendar, would that alleviate all the ambiguity? That's usually what I see in the civil world, but like I said, I'm no familiar person to the criminal law world, but I like your approach. So that's the one word that I think I would put in, though, if we were trying to eliminate uncertainty.
Yeah. Right. That, as Representative Carmichael just said, that may be the right fix, but let's work on it and decide in the future if we're all good with that. Yeah, Representative Burris.
Thank you, Mr. Chairman. I was just thinking, instead of calendar days, why not, 10 consecutive days? Something to indicate that it's just 10 days in a row, essentially, among other things.
This certainly could be an option. Representative Owens.
Do we use that in statute?
Well, and that's what I mean, if we're going to change this, I want us to be consistent on how we do other things. Representative Kincannon, do you have a solution? You're just smiling. You're just happy to be here.
We're happy to see here too.
Okay, do we have any other amendments at this point in time that anyone would like to make? Okay, what's the pleasure of the committee on the bill? That's why you're here, Representative Hoheisel.
Thank you, Mr. Chair. Sorry about that, guys. Mr. Chair, I move that we pass out HB 2299 favorably.
Is there a second? Representative, who did it? Oh, Owens, okay. Discussion. Seeing none, I'm not looking online. Don't see any there either. Back to you, Representative Hoheisel, to close. Heard the motion, all in favor say aye.
Aye. Aye.
All opposed say no. Motion carries. Those wanting their votes recorded, all in the affirmative at this point in time. Owens, Hoheisel, Carmichael, Heiberger, O'Hobson. Okay, let's move on to House Bill 2473. Natalie?
Thank you, Mr. Chairman. House Bill 2473 would remove the requirement that all of the district court judges in Douglas County serve on the Board of Trustees of the law library there.
Any amendments or any questions for Natalie first? Any amendments? What's our desire on this one? Representative Hoheisel.
Thank you, Mr. Chair. I move that the committee pass out HB 2473 favorably.
Is there a second? Representative Wheeler.
Oh.
Any discussion? Representative Hoheisel, you may close.
Close.
Heard the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. The yes votes that want recorded. Maybe not, I'm waiting on you, Representative Owens. There we go, Representative Owens, Representative Neely, Representative Hoheisel, Representative Carmichael, Representative Heiberger, and Representative O'Hobson. Now 2474.
Mr. Chairman, House Bill 2474 would allow a court to change a spouse's name to a name other than the maiden name or former name of that spouse during the course of a divorce proceeding.
Questions for Natalie? Representative Owens.
Will this include something like Charlemagne the God or other names? I mean, would those be included?
Mr. Chairman, if you look at the bill there, so in subsection A, if the spouse is wanting to return to their maiden or former name, then that's a mandatory name change. The court would have to make that name change. But in subsection B, which is what we're adding, It gives the court discretion to change the name if it's a different name than the maiden or former name. So that would all be within judicial discretion.
Excellent, thank you.
Other questions for Natalie? Are there any amendments? We have a motion concerning 2474.
I have a comment.
Yes, Representative Heiberger.
Yeah, to Representative Owens, I think you might recall Judge Picorni's testimony that she did have an unusual name change request come up during a divorce one time, and she declined it, and I think that's what would happen under the statute.
Representative Hoheisel.
Thank you, Mr. Chair. I move that the committee pass out HB 2474 favorably.
Seconded by Representative Neely. Discussion? Representative Hoheisel, you may close.
Close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. And we have the same list of affirmative votes, Kathy. We're just going to go with that from now on. The usuals. No, it did not. Right. You're right. He's only the second and third ones. Good job, Kathy. So the second list for the third bill. Okay, that's it for today, guys. We will see you next week. Again, be looking at, was it Senate Bill 102? And give me some feedback. Again, we can have Natalie brief that one. We can have others come in and tell us what it was about. Well, it was a bill that we heard last year. We did not work, but I'm anticipating working it this year. And so I just want you to glance at it, and I want you to be comfortable with it before we decide to move forward either way. So let me know. Okay, have a good evening, everyone. We're adjourned.